first case for the morning is Senuta versus Boston Township. Each part will have 15 minutes to argue. The appellant may reserve up to 5 minutes. How long would you like to reserve?
2 minutes, Your Honor.
That will be up there, over there, so it'll be kind of counting down, so just look at that top one when you see you get to 2 minutes and your time will be up.
Okay.
Okay? The argument is being recorded, so when you come up to the podium, please, number one, introduce yourself. Make sure you stay behind the podium so that you can be seen by the recording device, and make sure you can loud enough voice for everything to be heard. I don't think it matters if it's going to apply in this case, but if you were to be referring to any minors or victims or anyone, please refer by initials. Again, I don't think it is going to be relevant in this particular case. The attorneys have read your brief and are ready to proceed whenever you are.
Good morning, Your Honors. May it please the Court. My name is Tony Vicanti, and I am counsel of record on behalf of the appellants in this matter, Mr. Peter Senuta and Senuta Properties. Mr. Senuta is here in the room with his parents today as well for additional support. Your Honors, this case involves the intersection of constitutionally protected fundamental property rights and the limitations on a township's ability to zone and regulate those rights. I will be relying on the briefs for most of the facts, but there are a couple of pertinent facts that this Court should be aware of. The constitutionally protected property right at issue here is the ability of my client to utilize his commercially zoned property in a township that abuts a primary state route, State Route 8, for outdoor advertising purposes. He did apply to ODOT under ODOT's extensive regulatory scheme as set forth in Revised Code Chapter 5516 and the Ohio Administrative Code Chapter 5501. They reviewed the permit application, reviewed the site under the extensive regulations promulgated by the Director of ODOT as directed by the General Assembly, and issued conditional zoning certificates conditioned upon a final inspection of these billboards being erected. The problem arises here is when we went to apply to the township attempted to utilize its limited zoning authority to prohibit that which the General Assembly in the state has allowed, i.e. the construction of these outdoor advertising billboards. Here, the council is represented by very adept and intelligent counsel, Mr. Schrader, and you will hear a lot of, this is not a prohibition, but this is a regulation. And I would posit to this Court to listen closely to that, because these are regulations that are prohibiting these billboards, which conflicts with the revised code. So be aware of that semantics. That's where the trial court sort of fell by the wayside, got caught up with this non-distinction between prohibition and regulation, and fell in that trap. So I request that this Court don't fall into the same trap and uphold my client's fundamental property rights.
Are you suggesting that your client cannot have any billboards on his property under the Boston Township zoning?
I am. The way they have interpreted their zoning, Your Honors, I'm about to go through and articulate, because these regulations pretty much de facto prohibit billboards being constructed on this property. And again, there are only narrow properties on which a billboard can be constructed, and this is one of them. So it's a very, very important right. There are a couple limitations to township's authority that this Court should consider when reviewing the two main errors in the Court's decision. The first limitations are found in the statutes of the Revised Code and the Ohio Constitution. Under the Revised Code, townships are creatures of statute. They don't have any independent police power or zoning power. They only have that power that's delegated to them by the General Assembly through the Ohio Revised Code. Here, Revised Code section 519.20 expressly limits the township's ability to zone as it relates to outdoor advertising. It indicates that outdoor advertising in commercial zones, commercially zoned property in townships, must be classified as a business use and must be permitted in those commercial and business zones. That is the limit of the township's authority to regulate billboards. They can't. Additionally, the Revised Code section or chapter 5516, the General Assembly delegates that authority to regulate billboards within 660 feet of state primary highways, like State Route 8, to the Director of the Ohio Department of Transportation, not to townships. And there's an extensive regulatory scheme that one must adhere to in order to erect those types of billboards. So those are statutory limitations. There are also constitutional limitations. As the Ohio Supreme Court in Norwood versus Horney in 2006 indicated, property rights are fundamental under the Ohio Constitution, and they must be protected, and they cannot be trod upon lightly, no matter how great the weight of other forces. In that case, the court instructed local courts to strictly scrutinize, I shouldn't say strictly scrutinize, but scrutinize local decisions as it relates to use of property. Additionally, this case can invoke, depending on the direction this court goes, constitutionally protected free speech rights under the U.S. Constitution and the Ohio Constitution. So that's a limitation. This court has to scrutinize the township's decision-making in this case on those premises. The other limitation that overarches all of this is under common law, to the extent there's any ambiguity under the interpretation of zoning ordinance, that ambiguity must be construed in favor of the property owner because it is a fundamental right. It's well established, and it may not lead to an absurd result. Both of those limitations here are implicated with the township's interpretation of its own statutes. There are two primary reasons why the trial court lost its way in the decision below. First, the trial court erred in upholding the township's denial of my client's billboard applications based on the township's zoning resolution provision that prohibits signs from quote-unquote changing colors. The second reason is the trial court erred by concluding that the township's decision to deny my client's billboard applications was proper based off of a provision in the township zoning resolution that requires billboards or signs to be accessory uses as some other permitted use in the business district, and has to advertise goods and services sold on the premises, not general advertising purposes. Going into the standard of review, just briefly, the briefs sort of contradict each other on this point, and I think it's pretty clear. But unlike other administrative appeals, what we're dealing with here are purely legal issues, interpreting the revised code, the Constitution, the township zoning resolutions. Those are legal issues that this court must review de novo. So there's no deference to the trial court's interpretation of these issues, or certainly not the township's interpretation of these issues. So moving on to the first reason why this court should overturn and reverse the trial court's decision. The trial court erred, and again, denied my client's billboard applications by citing to a resolution provision that prohibits signs from changing color. That resolution section is 120102, and it states that signs are only allowed and are prohibited that contain, quote, animation, moving parts, flashing lights, or changing color. The township and trial court found that because the advertising copy on an outdoor advertising billboard changes, by implication, it must change color. That's wrong for a whole host of reasons. First, that interpretation is erroneous as a matter of law. That is regulating clearly changing colors within an advertising copy. Billboards, by their nature, have changing advertising copy. Here, there's no evidence that the advertising copy on the billboard itself will change, other than the advertising copy will change. On the electronic billboard at issue, it'll change approximately every 8 seconds, as required by the state. On the static, non-electric billboard, it'll change whenever the arrangement is up for the advertisers on that billboard.
So I can clarify.
Yep.
Then the billboard that your clients are wanting to install is electronic, and it doesn't change color whenever the new, every few seconds or whatever, it just stays like, what color does it stay?
There will be different colors on it, and you see these, probably you don't even notice them, quite honestly, driving up and down Route 8 or 77. There will be a message, the advertising copy on there for a minimum of 8 seconds. That's required by ODOT. And then it'll change, and there's a certain, into a different advertising copy, just like if it was a static, regular billboard, periodically you'll see the workers up there wallpapering something else back on. So,
Sure.
minimum of 8 seconds, which is required under ODOT's regulations.
Okay, so the messages will change color then? I'm not saying it's in violation, I'm just saying, I'm trying to figure out, it will be. Because you can have some that are electronic, like especially at the entrance of different municipalities and so forth. They'll have one just like to announce, what's going on in the village that day or whatever.
Correct.
And it'll just be like a yellow, and it'll flash different events, but it doesn't actually change anything.
Correct, but a lot of times you'll see the lettering may change on different notices, or it may change weekly to a different color. I see those all the time. Sometimes it'll be yellow, sometimes it'll be blue. What this regulation is getting to is you have the sign face and they're flat, like a Vegas marquee. There are flashes going on and all those things. That's prohibited by ODOT. What's interesting here is, and that you mentioned ground signs, Judge Carr. Here, the township actually has regulations pertaining to ground signs under section 1204C5, I believe, and it allows variable message signs. All right, so the township knows how to regulate changing messages because they've done it with regards to ground signs. This changing color regulation would actually act, if interpreted consistent with the township's interpretation, to negate the ground sign regulation on changing sign faces. It doesn't make sense because it's not intended to address variable message billboards. It will also lead to an absurd result because even static, non-electronic ones, again, if you change the advertising copy, which all billboards do, there are going to be different colors on it, and under the township's reading, that would be prohibited too. So, and finally, it also violates the canons of construction that the regulation of my client's property rights should be construed in favor of the free use of property, all right? So for those reasons, the township's position is wrong and the trial court erred. Even if that regulation was valid and it changes, prohibits variable sign faces, it conflicts with the Ohio Revised Code. Again, 519.20 allows or permits, as expressly permitted uses, billboards in townships and commercially zoned districts. This would de facto prohibit billboards because you would have the message in perpetuity on it. Under the revised code, section 5516.01, where it has definitions governing billboards, it defines a billboard, subsection A, it defines a billboard as a structure erected for advertising purposes where, and this I'm paraphrasing, where the owner of that billboard is compensated by third parties for advertising services. It naturally contemplates these variable sign messages. In addition, ODOT has specific requirements under the administrative code 5501-2-2-02 that allows and permits variable sign messaging. So basically what the township's doing is prohibiting what the General Assembly has permitted. And that, these regulations under Weir versus Rimelin are general laws of the state of Ohio, and this creates a conflict, even if they were valid, which I'm not saying they are valid, and would be invalidated.
You have about a minute left of your time, Council.
Thank you. And moving on to the second reason, it's a very similar reason. The township's zoning resolution prohibits billboards as accessory uses and requires any sign on property, including billboards, must advertise the goods and services outlined that are sold on the premises. Again, it's a clear conflict. The Ohio Revised Code 519.20 expressly permits outdoor advertising as a permitted use, not an accessory use, in business zoning districts, including all the case law we cited. There's not one case that has upheld an on-premises, off-premises distinction, meaning you're limited to selling, you're limited to advertising goods and services on the premise. All the cases support my client's position. The township has failed to cite to any valid case that allows it being just an accessory use. So for all these reasons and the reasons set forth in our brief, we respectfully request that this court overturn the trial court and honor my client's fundamental property rights. Thank you.
Good morning, Judges Carr, Stevenson, and Sutton. I'm Attorney Al Schrader. I represent Boston Township in this case. A couple of facts you probably should know. A, Boston Township is a gateway community to the Cuyahoga Valley National Park. We don't want the place looking like the entrance to Gettysburg. Let me explain why what they do is legal. First, the argument is, well, it violates 519.20. That merely requires that a outdoor advertising be permitted in a business or commercial area. But zoning has a lot of different permitted uses. You can have a conditional use, you have a primary use, you can have an accessory use. We permit them as an accessory use. There's nothing in that statute that defines what kind of use you have to allow for outdoor advertising. It just says you have to permit it, and we do, as an accessory use. Here's the requirement. It has to, in terms of the general use, it has to be an accessory use. That means there has to be some primary use of the property, and that billboard advertises either the goods or services that are offered by that primary use. The second argument is, oh gee, ODOT, the state preempted all this because of ODOT's regulations. ODOT itself has, in the statute, indicated that this chapter, and I'm paraphrasing, 5516 of the Revised Code shall not be construed to allow the erection of an advertising device in an area zoned by state, county, municipal, or other local authorities to exclude such devices. So it's not contrary to what the township is doing, and certainly the township isn't, quote, other local authority.
Council, obviously with zoning, with some other areas of law, regulations are one thing, prohibition is another, but there's, case law that provides at some point the regulations become prohibitory. In other words, you might just call them regulations, but at some point in time, they actually become prohibition, which is obviously not allowed. So he's saying de facto that's what you've done.
Well, that's possible, but that's not the case here. The fact of the matter is, if he had a primary use, which he doesn't, the owner testified there's no other use on the property. In fact, he said he didn't even know what was up there. So it's not accessory to anything. But the way it would be okay is, and it is a buildable lot, he could put a business or something up there. If he had a business and he had a sign, even a billboard that advertised what he produced, sold, or the services offered, that would be acceptable. So the fact that in his unique circumstances, he's not allowed to have it, doesn't mean he couldn't have it even on his own property, and it certainly shouldn't be held to keep the township from regulating anything else in the township, particularly because of the existence of the national park. There's your aesthetics, there's your concerns about safety. The other problem is, there's a justification for that exemption I just read to you on the ODOT thing, and that is, ODOT is concerned about the state highways, and that's the only thing in the world they're concerned about. They don't care about zoning, they don't care about light shining in a kid's window, which was some of the evidence we heard at the hearing. They don't care about state they care about state roads, they don't care about township roads, county roads, or other such roads. So that's why, both from a policy standpoint and literally within the statute, ODOT is not a prohibition to the township doing what it seeks to do up here. As to the change in color, first off, the burden of proof on these issues, even at the BZA, is on the petitioner, on the guy that wants to put in that particular use. They're the ones that should have had somebody come up and testify, hey, you know what? We don't have animation, we don't change colors, our light is not excessive, etc. They didn't. They didn't say we don't change colors. In addition to that, it's kind of a convoluted argument. As I was reading, again, appellant's brief, they conflate the two billboards that they propose for that property. That's another fact you ought to know about. On this one property, they want two billboards, one digital, one a traditional, send out the guys with the paper and they change the sign. The township acknowledges that the change in color relates to the digital sign only. We acknowledge that. We believe, when you read the order appealed from, that's what the trial court was talking about, is the digital sign. It's a pretty common argumentative technique to parade the horribles and set up a straw man. But that's not the reason we ban or prohibit, in this particular instance, what I'm going to call the stationary sign. It's the arguments I just made that take care of the stationary sign. The digital one, and sometimes, I guess we call it judicial notice, it's otherwise known as common sense. I've never seen a digital sign that doesn't change color. That's the nature of it. They're like a massive television. And I think the trial court used that to explain. Now, why do we do, as a policy matter, why do we not like a change in color? A, it's distracting to drivers. Maybe the state doesn't mind it for the state highways, but we sure do on those curving roads up there in the national park in Boston Township. That's a problem. The fact that it does change color is not only distracting, but the light effects when that happens have a detrimental effect on neighbors that may be residing close. This thing is close to the national park, it's close to Hudson, it's in Boston Township. The other reason is aesthetics. I was a little surprised to hear that no court has ever held that a sign that does not advertise stuff sold or produced or goods and services offered on the property, that somehow a prohibition on that has always been found not to be the case. Your sister district in the first district held in a case that I think both sides referred to repeatedly in the brief, that and this involved a municipality, that in an urban setting where you had buildings very close to the sidewalks, an off-premises sign was okay to prohibit because it violated the aesthetics of an urban area. Now, if that's the case, if we ever got to that issue, it's even more so that such an off-premises sign violates the aesthetics of the national park. And that's a deep concern of the township. My clients always want me to remind everybody that 88% of their property is non-taxable, and townships rely on property tax. So their commercial areas are very important to them. The national park, because they're a gateway community to the national park, is pretty much essential to the survival of Boston Township. So that's why they're so concerned about the township itself. Interestingly, my opposing counsel, who's an excellent attorney and I thought did a fantastic job in this case at all levels, has said that his suggested remedy is that you reverse and enter final judgment. How do you do that on that constitutional argument? The trial court never took it up. It talked about it a little bit, said, I'm not ruling on this because we don't need to, because it's resolved on other issues, and the long-standing law, of course, is that you don't take up a constitutional issue if you don't have to. How do you reverse on that? Shouldn't we at least let the trial, if you decide, and I don't think you will, but if you decide that every other argument I made makes no sense, then wouldn't you remand it so the trial court can actually do its job and give you something to review? So even the remedy isn't good enough, isn't correct. Lastly, as I'm sometimes...
The trial court correct in finding the constitutional issue shouldn't have been reached. Once it decided none of these statutory reasons that exist were enough to let the landowner build their property, didn't the trial court have to review the constitutional argument to see if it violated, if your statute violates the Constitution?
I don't know if we would have to. I can't tell you I'd object if she had, because I think even there we win. I mean, the issue is, this isn't a strict scrutiny issue. We just have to be reasonable in the concerns we have. So our concerns are safety, aesthetics, the national park. Nobody suggested a less restrictive way of dealing with this than what we do. We do allow billboards if they meet all the criteria I've said before. So I think we would if we got to that issue, I think the township would prevail on it. I'm not sure the city, it's a great question, because I never gave any thought to it prior to now. I'm not sure the trial court's required to take it up, but if they did, I wouldn't have any problem with it.
Well, you don't contest that they raised constitutional issues.
I'm sorry?
You're not contesting that they raised constitutional issues.
No. They raised the constitutional issues, I think we briefed it a little bit, not terribly extensively, and the court handled it as it did. It talked about it briefly, seemed to indicate it's, well, maybe I read too much into it, but I think the court indicated it would probably have ruled in our favor, but decided not to take up the issue. Lastly,
You have about 4 minutes left, Attorney Schrader, our clock has stopped working.
okay, I'm not going to need them. I should have started with the standard of review. And, you know, clearly, I think we actually agreed on the standard of review. If the issue is the law, it's de novo. But if the issue is the factual issue, you know, who do you believe, what are the facts, then that's abuse of discretion. And that kind of takes us back to that color thing. The argument that every time it changes its face does not necessarily mean it changes color. I think opposing counsel pretty much indicated it would change color, so I don't want to spend a whole lot of time on that. Unless you have additional questions, I'd be more than happy to.
Yeah, counsel, so if the same proposed billboards were associated with accessory use, something related to the property, some sort of product being sold, would they be permitted?
Yes. If they built a business or opened a law office, if Tim Misney located up there, for goodness sake, and put in one of his goofy billboards, that would unfortunately be allowed, because that's what the zoning says.
Okay, so the same billboard could conceivably, even if it had some changing color.
If it met the requirement. Now, if there's this, I'd have to look and see if we have a separate prohibition just on color. But yeah, as long as what I'm trying to say is as long as the billboard meets the requirement of that zoning resolution, it would be allowed. And they are allowed in properties that do meet that requirement.
Well, I'm confused now.
Okay.
Okay, I thought that there were two reasons why it wasn't allowed. One was because there's two different billboards, the static and the electronic, okay? The electronic changes colors, change face, all those type of things, which would never be allowed, right?
That's correct, and I'm
Okay,
sorry.
so it doesn't matter if it's an accessory use or not.
That's correct, and I apologize.
Okay.
The difficulty in this case was you got two billboards on one property, and it's very easy to confuse those. I think perhaps both sides did that in our briefs. But the answer to your question is the digital one would not be allowed, but the stationary would be allowed. And thank you for catching that, Judge Carr.
I just wanted to make sure I understood it.
Thank you for that clarification.
Well, thank you, and I'm sorry I was a little confusing there. So if there aren't any other questions, I'm going to sit down and shut up. Thank you very much.
So I have a few items to address based off of Mr. Schrader's argument. Mr. Schrader's confusing the constitutional case law and the statutory case law. When I said there's not one single case that has found that an on-premises advertising, off-premises advertising was valid, I meant under 519.20 and the regulatory statutory scheme. I was not talking about the constitutional intermediate scrutiny. Every single case cited, the case cited by Mr. Schrader involved the constitutional issue. There's Summit Locations LLC versus Sheffield versus Washington Township. The Hasman versus Genesis Outdoor, American Outdoor Advertising Company, Barnes, and Malfi, all cited in the brief, all found that distinction to prohibit billboards illegally under 519.20, just to be clear. And with regards to permitted uses, 519 versus accessory uses, they're two different things. 519.20 expressly permits them as business uses. Business uses under Chapter 7 of the Township Zoning Resolution are permitted outright, they're not accessory. So I think it's important to note that Mr. Schrader, with all due respect, in the record, in the July hearing, I think it's record items 11 and 12, expressly told on pages 52 to 53, my client, that if this is approved, no other structure can go in this building because only one use is allowed on the property. It totally contradicts what Mr. Schrader's arguing today. So I just wanted to point that out. There was a lot of discussion over items not in the record as the gateway. This property isn't next to the park. There's no evidence of lights shining in windows. Someone testified in the adjacent community that he was concerned over that, but there was no evidence with regards to that. And then finally, with regards to the constitutional questions, the trial court didn't reach it because it was in fact moot, because the trial court found that the billboard changed colors, so it didn't reach that constitutional issue. If this court finds in my client's favor as to that issue, but finds in the township's favor as to whether it's prohibited because it only can be an accessory use, then that constitutional issue would arise and should be adjudicated. But it's not right for review right now based off of where we're at. That case law is fully briefed, and I think it's pretty clear. Binding Ohio precedent requires intermediate scrutiny and the burdens on the government to establish a substantial governmental interest, which safety we concede. We just don't believe it's narrowly tailored because the billboard's facing State Route 8 in an adjacent community. It's not on winding township roads. It's permitted by
Thank you,
ODOT.
counsel, your time.
Thank you, Your Honors. Appreciate and look forward to the reversal. Have a good day.
All right, thank you both for your presentation today. The court will take the matter under advisement and issue a decision in due course. When that decision is ready to be reached, it will be mailed to you by the clerk of court and also will be on the Ohio Supreme Court website.